Hello everyone and welcome to this video tutorial on elements of a crime and omissions. There are two key elements of a crime that need to be present in order for the defendant to be convicted, and these are the actus reus and the mens rea. And these are Latin phrases which come from this big expression that you can see here, actus non facit reum nisi mensit rea. Luckily for you, you don't need to memorise this long phrase. You just need to memorise actus reus and the mens rea. I'm just showing you where these terms have come from. So this ancient Latin phrase means that conviction of a crime requires proof of a criminal act, actus reus, and a criminal intent, the mens rea. So in order to be guilty, our defendant has to have both of these. Today, we're going to focus specifically on the actus reus. The actus reus of a crime is the voluntary, deliberate act of the defendant. So in a murder, if I decide to kill Jared by stabbing him, the actus reus of murder would be the physical action of killing him. And in that situation, if I've stabbed him to death, it's the voluntary, deliberate action. But sometimes with crimes, it's not always so obvious that your defendant has committed the actus reus. When I've stabbed Jared, my action appears to be voluntary, but we need to consider today what if it appears to be involuntary. And in my example where I stabbed Jared, there was a positive act. But what we'll also need to consider is what if there's not been a positive act, what if there's a failure to act? Consider that first issue then. What if our defendant is acting involuntarily? When proving that the defendant has committed the actus reus, the prosecution must prove that the accused person voluntarily brought about the actus reus of the crime, meaning that the act occurred because of the defendant's conscious exercise of will. And the key case that we've got to illustrate this is the case of Hill and Baxter. Hill and Baxter was a case where the defendant was driving a car and he claimed to have been unconscious as a result of being overcome by sudden illness. He was convicted though because the court believed that he was still managing to control the car. But what was useful about this case is the court provided this key principle that in order to be guilty of a criminal offence, the actus reus must be voluntary. And the court gave some examples of where a driver of a vehicle would not have been driving voluntarily. And they're a little bit strange, some of these. So the court said if you were driving and you were being stung by a swarm of bees, or you've been struck on the head by a stone, presumably you're in a convertible then, or you've had a heart attack whilst driving, in those situations you wouldn't be driving voluntarily and therefore shouldn't be guilty of a criminal offence. And this rule that the actus reus must be voluntary seems to be a fair one. In a different context, if let's say a student was having a fit, an epileptic fit in one of my lessons, and I go to assist them, and as they're fitting, one of their legs kicks me and I get a bruise, it'd be unfair if I could prosecute them for an offence of kicking me because their body was out of their control at that time. So that's the situation with involuntary actions. So in general, you will not be guilty of a crime through an involuntary act. The actus reus must be voluntary. Let's consider the second situation then. What about if the person hasn't done a positive act, but rather they've done an omission? And an omission simply means a failure to act. So what we're looking at here is, can you be guilty of a crime through failing to act? So to get us thinking about this, I want us to imagine these situations. Okay, so first of all, let's say this is me and I'm walking down a street and I see a burning house and somebody inside. Would it be a crime if I just walk past and let them burn to death? Second situation, I'm walking along, exercising at the weekend, and I see this poor person about to fall off a cliff. And I could quite easily help them back up. They hold out their hands, they say, "Please help me, Lucy, just pull me back up." And I go, "No." And they fall to their death. Would that be a crime? Next situation, I'm walking past this deep hole and I see this gentleman in there and he shouts up that he's starving. Please, can I help him out? And I say no, and I walk on by and he dies of starvation. Am I guilty of a crime? Next situation, I'm walking home from work and I see this poor gentleman unconscious on the street, maybe he's bleeding as well, and I just step over him and go home. And he later dies. Am I guilty of a crime? Next situation, this poor guy here is drowning and I'm on the beach having a picnic and I see him drowning and I do nothing and he dies. Am I guilty of a crime? This appears to be some very small child who appears to be lost, wandering down the road on their own, and I see it and just walk on by, and the child's struck by a car and dies. Am I guilty of a crime? So it'd be useful to pause the video at this point just to consider those issues for a minute, and then I'll come back to you. Okay, have you thought about it? So this might come as a surprise to you, but in all of these situations, if I just ignored the poor people in peril and just carried on with my day and they've all died, I'm not guilty of any crime. If I don't do anything, if I don't try to help, that makes me a very unpleasant person. Morally, I've done something very bad, I would say, but legally I haven't. And that's because the general rule on omissions is that an omission cannot make a person guilty of an offence. So in general, if you fail to act, so if I switch back for a second, if I fail to get help, if I fail to try and help these people and they die, it's not my fault, it's not a criminal offence. That is the general rule. And most students find that quite surprising when they first come across this rule. There are, however, some exceptions to it, which we're going to look at. Look at the exceptions to the general rule. It's useful to think, why do we have this rule? This rule seems a bit strange because we're allowing people to ignore other people who clearly need help, and that seems immoral. Why does the criminal law do that? And there are many reasons for it. There's firstly a practical reason in that how would you be able to prove somebody had witnessed something? In a big disaster situation, how many people have to act? Might it be that the person's going to make the situation worse? There's also a real problem in expecting somebody to risk their own life to save somebody else. The person might make the situation worse and then actually be sued for making the situation worse, because we're in a litigious society. We live in what we call a compensation culture. So if you try to help someone and maybe you make a mistake, it's possible that they could sue you afterwards. So that might put people off coming to assistance as well. So there are some reasons why we have the rule, but there are, of course, exceptions to it. So there are some situations where you can be guilty of a crime through failing to act. And we're going to have a look at each of these in turn. So duty through a contract, through a special relationship, through assumption of care, through official position, creation of a dangerous situation, and through an act of Parliament. The first exception to the general rule on omissions is duty arising out of a contract. So if a person owes a contractual duty to act, then a failure to meet this contractual duty can result in criminal liability. And that's illustrated in this old case of Pitwood. And our defendant here was a signalman employed by the railway company, and his job was to close the gates when a train was passing. And he'd left the gate up, went off for his lunch, and somebody was killed on the railway. And the defendant was convicted of manslaughter. And if you think about that, he hasn't done a positive act. He hasn't pushed someone onto the railway track and they've died. The person has died because of his failure to close the gates. And because he had a contract to close the gates, he was guilty of an offence. So you can owe a duty through a contract. In one of the examples I gave you earlier on, if I saw a man drowning and I just walked past, I'm not going to be guilty of an offence. However, a lifeguard couldn't walk away without trying to help them because they would have a duty through a contract. The second exception to the rule is duty arising out of a special relationship. And this is a particularly unpleasant case, this. Gibbons and Proctor, we've got two defendants here. They were partners that lived together. Partners, Gibbons and Proctor, had several children and they lived together in a house. And for some reason, they took a dislike to poor 7-year-old Nellie. And so they locked her in a shed and failed to feed her. And she died of starvation. And afterwards, they told all the other children she'd gone away, when in fact, the dad had buried her in a brickyard where he worked. They were convicted of murder and they appealed. And their argument is basically, well, we shouldn't be guilty of murder because we've not done a positive act. We didn't stab her. We just failed to feed her. And in general, you can't be guilty through failing to act. But they were guilty, you'll be glad to hear, because they owed a duty to act through their special relationship. So parents will owe a duty to their children. So I can watch someone else's child starving hungry, but I can't watch my own children starving hungry because I have a duty to them as their parent. The next exception is duty from assumption of care. So this means where you volunteered to look after somebody, you then owe a duty to do so. So Stone here lived with his mistress Dobinson, and Stone's sister Fanny, who was 61, came to live with them because she couldn't look after herself. She was suffering from anorexia nervosa, and although at the start she could do some things for herself, her condition deteriorated. And she died weighing less than 5.5 stone in an excrement and urine soaked bed with 2 large maggot infested ulcers. The reason I'm telling you these rather grim facts is so that you can appreciate how bad the situation was, and yet S&D still did nothing. S&D were convicted of manslaughter through failing to summon help or care for her. And they were held to owe a duty through an assumption of care. So again, they've not done a positive act, they've not stabbed her, but their failure to look after her has caused her death. And although we don't usually punish people for an omission, they had a duty to act because they had volunteered to look after her. And they could have summoned help quite easily. Exception is duty through official position. And in Ditham, the defendant was a police officer, and he stood by whilst a bouncer kicked a man to death. And he was charged with the offence of misconduct in a public office, but he argued that the offence couldn't be committed through an omission, and all he'd done was fail to act. But he was held guilty. The offence of misconduct in a public office can be committed by an omission, and the defendant owed a duty to act through his official position. Our next duty situation is a duty arising from the creation of a dangerous situation. And this is where if the defendant starts a dangerous situation, they're then under a duty to do something about it. So in Miller, our defendant was squatting in a house. He fell asleep smoking and woke up to find the mattress on fire. And instead of doing anything about it, he moved to another room, went back to sleep, and the house caught fire. Luckily, no one was injured, but there was a lot of property damage, and the House of Lords upheld his conviction for criminal damage. And although he had simply failed to act when he saw the fire, it was held that he owed a duty because he had created that dangerous situation. The final exception is duty through an Act of Parliament. So an Act of Parliament can create liability for failing to act. And examples include you can be guilty of a crime if you fail to report a road traffic accident or you fail to provide a specimen of breath. They're both omissions, but the Road Traffic Act says that they're a crime, so therefore they're an exception to that general rule. Although doctors owe a duty to act through their contract, that duty will come to an end, that cessation of a duty. And a doctor's duty to act will end when no longer in the best interests of the patient. And that's illustrated by Iredale, NHS and Bland. And it was also confirmed in the case of Alder, Hay and Evans. Distinguish that from Pretty, where a positive act would be illegal.